Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here to talk about this motion that the prosecution filed today. I didn't even get a chance to go into detail with you guys about Judge Donnelly's decision about not allowing anyone into the courtroom other than the prosecutors, the defense, and the witnesses that will testify. Everybody else has to be held in a separate courtroom, an overflow courtroom. And then I guess they'll watch the case. I don't know how they're going to play this out. But then she turned around and supposedly has denied the use of a call-in line, like an audio line. And if you remember in one of my prior videos where I talked about Harvey Weinstein, and what happened in his case was that no recording devices, cameras, or anything was allowed in his case. And what they did was they have transcribers in the courthouse who's transcribing the testimony, and then they'll go and I guess it's going to a machine or something. But I was watching the Harvey Weinstein case on Court TV, and probably like every hour or 2 hours they would get this transcript, and then they would do a reenactment using voiceover in order to let the audience know what was going on in the courtroom. And then if there was like some big aha moment, the reporters would run out and get on camera and talk about whatever that was. So it seems like Ann Donnelly is kind of moving along that route. And the guy, Matthew Lee, who was actually bringing this information, he is from Inner City Press, and he talked about how in other court cases they were allowing the audio, the video conferencing, so that reporters, could be abreast of what was going on. And he didn't understand why Judge Donnelly was prohibiting the use of teleconferencing and audio conferencing, and so trying to do a little more research on that. But now the prosecutors have come out with a motion where they want the witnesses, and three of the witnesses, the Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5, who we already know is Azriel Clary. So I don't even know why she playing like this. I guess Geronda Pace don't care because she's Jane Doe number 4. She don't care if we know who she is. And then Faith Rogers, who is Jane Doe number 6, doesn't care, I guess. If people know who she is, they don't mind using their name, their face, whatever. And then the Jane Doe number 2 and Jane Doe number 3 is the two people that they have kept a secret since the beginning of this, and the defense only found out who these two people were back in April. And so it will be interesting to find out who they are. But let me go ahead and get into this motion. So it starts out with a preliminary statement. And in that statement, they say the government respectfully submits this memorandum of law in support of its motion in advance of trial in this matter, currently scheduled to commence on August 9th, which we know the judge has pushed back to August 18th. And it says the motion seeks to protect the identities of certain charged victims referred to as Jane Doe number 2, number 3, and number 5 in the third superseding indictment hereinafter referred to as the victim witnesses that are expected to provide and or will be the subject of sensitive and personal testimony concerning alleged abuse, contact, and other acts allegedly committed by the defendant at trial. Specifically, the government moves the court to 1, permit the victim-witnesses to testify using pseudonyms or their first names only. 2, limit references to each of the victims/witnesses in open court to their pseudonyms or first names only. And 3, prevent public disclosure via cross-examination or otherwise of the victims/witnesses' respective addresses, names of their family members, or exact place of employment, if any. And we already know that Jane Doe number 5 ain't got no job, so we don't have to worry about that. And we already know who her parents are. So what is the big secret, Azriel, Angelo, and Alice? What are y'all trying to prove here? So then it goes background. 1, the charged conduct, and it talks about on March 12, 2020, a grand jury in the Eastern District of New York returned a 9-count third superseding indictment charging the defendant with racketeering and alleging 14 racketeering acts, including bribery, kidnapping, transportation, and of minors and other individuals for the purpose of doing the do, illegal coercion and enticement of individuals, and forced labor, as well as violations of the Mann Act related to the transportation of individuals for the purpose of doing the do, the illegal coercion and enticement of individuals, blah, blah, blah. Along the charges are offenses that carry a 10-year mandatory minimum sentence. The defendant's alleged victims are identified sequentially in the indictment as Jane Doe number 1 through Jane Doe number 6. And then we know that Jane Doe number 1 is Aaliyah. And what I find interesting about Aaliyah in this indictment is that when you go into the Pacer account and they list all of the charges against him, all the counts against him, nowhere on there does it mention bribery. And remember, that was what they added into the indictment when they added Aaliyah to the indictment, was that he allegedly bribed this witness or this government official or whatever to give this fake ID. And that is not listed among his charges. And so I have been looking at that for a while now, trying to figure out, did they drop the bribery charge and change it to something else? Like, what's really going on with that? So it goes on to say the government anticipates that the charged victims, Jane Doe number 2, Jane Doe number 3, and Jane Doe number 5, will be called as witnesses at trial and will also be the subject of testimony and other evidence elicited at trial. A. Jane Doe number 2, the indictment charges the defendant with racketeering, including predicate racketeering acts involving Jane Doe number 2, an individual whose identity is known to the government and the defendant. Jane Doe number 2 is expected to testify that she met the defendant in or about 1999 in Chicago when she was 16, after a member of the enterprise approached her at a fast food restaurant and informed her that the defendant wished to speak with her. Thereafter, Jane Doe number 2 was a minor under 18. The defendant engaged in acts or conduct with Jane Doe number 2 on multiple occasions, filmed Jane Doe number 2 with the defendant, thereby producing CP. Jane Doe number 3, and then go back to Jane Doe number 2. So is Jane Doe number 2 Heather Williams? Because it seems like this story just keeps changing. In the Cook County indictment, they say that she was celebrating a birthday at a restaurant. Then when she went to sue him in the civil court, she claimed she was walking down the street and he asked her if she wanted to be in the video. Now we got Jane Doe number 2 was eating at McDonald's. Okay, so who exactly is Jane Doe number 2? And I will have to go back and review my old notes, to get all this stuff straightened out in my mind as to who this person is. And so then we go on to Jane Doe number 3, and it says, the indictment charges the defendant with racketeering, including predicate racketeering, acts involving Jane Doe number 3, an individual whose identity is known to the government and the defendant. Jane Doe number 3 is expected to testify that she met Kelly in 2003 at a mall outside the state of Illinois when she was in her early 20s and working as a radio station intern. The defendant thereafter invited Jane Doe number 3 to travel to Chicago, Illinois, purportedly to conduct an interview of him in connection with her employment at the time. Following her arrival in Chicago, Jane Doe number 3 was directed to a recording studio. Once there, she was escorted to a room within the studio by one of the defendant's associates, who also took and searched her suitcase. Later, while in the room, another associate made a copy of Jane Doe number 3's driver's license, directed her to sign what she believed to be a non-disclosure agreement, and advised her not to talk to anyone and to keep her head down. Jane Doe number 3 ultimately spent approximately 3 days in the room, which was locked without sustenance. After a member of the enterprise eventually provided her with food and a drink, she became tired and dizzy. She woke up sometime thereafter and saw the defendant was with her in the room and that her underwear had been removed without her knowledge or consent, which in combination with other circumstances made it apparent that the defendant had abused her while she was unconscious. Now, how does she know he abused her if she says that there was other people there that took her in the room? Why is it that none of them abused her? C. Jane Doe number 5, the indictment charges the defendant with racketeering, including predicate racketeering acts involving Azrael Clary, Jane Doe number 5, an individual whose identity is known to the government, the defendant, and everybody else. He is also charged with substantive Mann Act violations involving her as well. She's expected to testify that she met the defendant in or about 2015 in Florida when she was 17, after a member of the enterprise approached her at a concert and gave her the defendant's telephone number. And we know already that Jane Doe number 5 about to get up here and lie just by that sentence alone. Thereafter, while Jane Doe number 5 was a minor under the age of 18 and in violation of applicable state law, the defendant engaged in a relationship with Jane Doe number 5 and or on multiple occasions, filmed them, thereby producing CP as a result of the defendant's actions. Jane Doe number 5 contracted an incurable disease at the age of 17. Okay, so did she go to the doctor, y'all? I mean, because they only knew each other for a few months before she turned 18. Did she go to the doctor and get checked for this STD prior? I mean, like they had just met, all right? So when did she know she had this STD that she's not claiming that she has? So anyway, let's move right along. So then, in addition, she claims that physical force, threats of physical force, physical restraint, and threats of physical restraint and other means of psychological coercion to cause the Jane Doe number 5 to engage in activity not just with the defendant, which she consented to which she consented, y'all, is there in parentheses, but also activity with many other women and a man. The activity with the others was always at the defendant's direction and in the defendant's presence and often filmed for the defendant's use. Now, was this before or after they was running around at the beach having fun? Was this before or after she told her dad that she was in New York having the time of her life and didn't want to be bothered with him or her mama? Was this before or after all of that was transpiring? So then they move into their argument, and it says, at trial, the government expects that the victim witnesses will testify and or be the subject of testimony and other evidence relevant to the crimes charged in this indictment. Due to the sensitive nature of the testimony and evidence, as noted above, the government moves in for the court to, one, permit the victims to testify using fake names, for them not to use their names in open court and to only refer to them by the first name or the fake name. Prevent public disclosure via cross-examination or otherwise of the victim witnesses' respective addresses, names of family members, or exact place of employment, if any. So basically, they ain't got no jobs, but they want to protect them if they happen to come across one before this trial starts. So as discussed below, these measures are necessary to protect them from potential harassment from the media and others, undue embarrassment, and other adverse consequences. Now, Jane Doe number 5 can't be embarrassed no more than she done already embarrassed herself, because now was she not the one that sat there and said that she ate her own poop? Now, once she said that, there really is nothing else that should be able to embarrass her. Okay, so we're going to go on with this. Okay, it says, one, legal standard. The Confrontation Clause guarantees defendants in all federal and state criminal prosecutions the right to confront government witnesses testifying against them. A defendant's right under the Confrontation Clause must yield to accommodate other legitimate interests in the criminal trial process. Chambers versus Mississippi. For instance, the Supreme Court has observed that there is wide latitude insofar as the Confrontation Clause is concerned to impose reasonable limits on such cross-examination based on concerns about, among other things, harassment, prejudice, confusion of the issues, the witness safety, or interrogation that is repetitive or only marginally relevant. In deciding whether to limit the scope of cross-examination, the court must balance the government's reasons for requesting such limitations against the defendant's interest in the full cross-examination of the witness. Alford versus United States, Smith versus Illinois. If the question asked is one that is normally permissible, the state or the witness should at the very least come forward with some showing of why the witness must be excused from answering the question. Why do the witness need to be excused from answering any question? How are you going to accuse somebody of something and then not want to be asked about it on the witness stand? The trial judge can then ascertain the interest of the defendant in the answer and exercise an informed discretion in making his ruling. These people are crazy. In the trial context, courts have found that the potential for reprisals, humiliation, or annoyance are sufficient to justify non-disclosure of personal identifying information by a witness. The Honorable Alan R. Ross, District Court Judge in the Eastern District of New York, surmised, in advancing the contention that the defendant's rights under the Confrontation Clause of the Sixth Amendment require full disclosure of the witness's name, place of employment, and home address, the defendant relies on Smith versus Illinois and Alford versus the United States. From 1968 and 1931, y'all. These aren't even recent cases. Taken together, these cases have been interpreted by the Second Circuit to safeguard two main interests of the defendant. One, obtaining information needed for in-court and out-of-court investigation of the witness, and two, enabling defense counsel to elicit information that might be relevant to the jury's deliberations as to the credibility or knowledgeability of the witness. In the event the government seeks to limit disclosure of identifying information in court, the government must provide a reason for the limitation. The reason may be that the answer may subject the witness to reprisals, or that the question is being used to humiliate or annoy the witness. The defendant is then, where I said at, they were marking what page that is on. So a new sentence starts. The defendant is then required to demonstrate a particularized need for disclosure of the relevant information, which the court weighs against the risk of the witness. So now they want to protect the witnesses from being humiliated, but they are okay with sharing information or allegations against the defendant that may be humiliating and may also be untrue and unfounded. So it's like, if you are coming forth to tell your story and tell what happened, should be any limitations on what the defense can ask you regarding that. Like, that makes no sense, because you're not giving the jury, full disclosure of information to make the right judgment. If you're going to be skirting issues and saying, oh, you can't ask them this or can't ask them that to me makes absolutely no sense. But anyway, it goes on to say, in United States versus Marcus, the court relied in part on United States versus Marty, which is from 1970. And it says, in which the Second Circuit analyzed the Supreme Court's holdings in Smith and Alford and ultimately concluded that there was no prejudice to the defendant where he was precluded from inquiring about a witness' address. Okay, well, we don't need to know their address. Okay, but anyway, the Marcus court held that although the government should come forward with a reason for withholding a witness address, the reason may be that the answer may subject the witness to reprisals, or that the question is being used to humiliate or annoy the witness. How asking somebody for their address? Like, why would you even be in the middle of the trial asking for their address? I don't understand that. I can see them asking for the address so they know where they can go to start investigating, and asking questions of people who know this person or may have known them or may know about this story that they have told to the feds. I don't understand. Maybe I'm missing a part on why the defense would be in the courtroom revealing the person's address. But anyway. So the witness, ruling that potential harassment, potential loss of employment, and the explicit nature of anticipated testimony are legitimate reasons to protect witnesses' full identity and to exclude mention of witnesses' home addresses and current places of employment. So, if you're going to be talking about place of employment, the only thing I think would be humiliating or embarrassing is if they are porn stars or they work at the strip club or something like that. Like, what else could they be doing that would embarrass them if anybody knows? Okay, then we move on and they talk about, in another case, finding no error in precluding cross-examination regarding witnesses' home addresses. United States versus Navarro, cross-examination of an informant about his home address and current place of employment precluded. And then they just list several cases where they refer to the person's home address, but we know that the information that they're trying to get stricken or keep the defense from asking has nothing to do with these people's home address or place of employment. So anyway, it goes on to say, in addition, the Second Circuit has upheld non-disclosure of full identifying information in order to protect the safety of the witness and his or her family. And then they go to list several court cases. And then it goes down and says, where the government seeks to limit disclosure of a witness's identifying information in court, the government must articulate a need for withholding the identifiers, such as fear of reprisal, humiliation, or annoyance to the witness. Once the government identifies a need to protect the witness' full identity, the defendant must demonstrate a particularized need for the information, which the court weighs against the harm to the witness. Judge Ross expressly found in a case involving trafficking allegations that, in light of the explicit nature of the conduct that the witness will be testifying about, the court has determined that the witness's fear of harassment and reprisal is legitimate. Similarly, in another trial case in this district, the Honorable Sandra Furstein, the district court judge in the Eastern District of New York, also permitted victims testifying in graphic details about acts of forced prostitution and other contact with customers and others to testify using their first names only. In addition, in a case where the defendant was charged with abuse and assault on an airplane, the Honorable Carol A. Amon, District Court Judge in the Eastern District of New York, permitted the victim witness to testify using her name only. And then it just goes down, just listing different court cases where it was approved for the person to only use their first name or fake name. And then they talk about in the United States versus Carlos Richard Martinez. It says here, Jane Doe is expected to testify in explicit detail about allegedly being the victim of degrading and humiliating treatment by the defendant. The case was already received significant national and local press coverage. Revealing Jane Doe's identity would likely cause her anxiety and risk social stigma. More broadly, requiring Jane Doe to disclose her identity could chill the willingness of other alleged victims to come forward. Furthermore, defendant has not identified any particularized need for the disclosure of Jane Doe's identity information in open court. Defendant already knows who Jane Doe is and will not be prevented from mounting a defense in the event that she is referred to only as Jane Doe. Additionally, although her address, family members' names, and place of employment are entirely irrelevant to her testimony, disclosing those details risks allowing third parties to identify her. Moreover, at certain sentencings of traffickers, courts in this district have permitted victims to give in court victim impact statements using only their first name or the name Jane Doe. The order permitting victims to make statements using fake names and noting that victims were permitted to testify at trial using nicknames, first names, or pseudonyms. And then that was from United States versus Angel Cortez Granados and United States versus Benito Lopez Perez, who I'm sure are people that were charged in crimes that actually, really harm people in a really bad way. Except the only person I'm really not sure about is Jane Doe number 3 and her story. But these other folks, we already know were after him and got themselves into some situations and now are coming back with these fantastical stories that they're telling. So the limited protections requested by the government for the victim witness personal identifiers are reasonable, necessary, and appropriate to protect their safety and well-being, avoid harassment by the press and others, and prevent undue embarrassment and other adverse consequences such as retaliation by the defendant's supporters. Yeah, y'all, they went there. They say retaliation by the defendant's supporters, need for relocation, or loss of employment. Okay, first of all, we know Jane Doe number 5 ain't got no job. Okay, let's start with there. She doesn't have a job. She posted all over social media. Geronda posting all over social media. Faith posting all over social media where they are, what they're doing, and everything else. So why are we trying to make it seem like these people need protecting when ain't nobody bothered them in the past 2 years, and nobody is really, we make fun of them and the stupid stuff they do, but nobody is harassing them, targeting them, or doing anything to them. So they are reaching here. So then it goes on to say the alleged victims' witnesses are expected to testify in explicit detail, which you've already said, personal testimony concerning their medical history, their alleged abuse, some of which occurred allegedly while the witnesses were underage. Since the defendant's arrest, the case has garnered significant attention from local, national, and international media sources, which can only be expected to increase during trial. The defendant's arrest and indictment received widespread coverage in the media, and the case has continued to receive significant attention given the defendant's career as a well-known musician and the nature of the charges. The news coverage has not only centered on the defendant, but also has focused on alleged victims, attempting in certain instances to identify unnamed victims in the indictment through various channels. In addition to the attention that the case has received from the press, the case has likewise garnered widespread attention and discussion via multiple social media platforms such as Facebook, Instagram, YouTube, and Twitter. This attention has not only consisted of discussions regarding the case generally, but has included attempts by members of the public to determine the identities of the Jane Does named in the indictment and other potential witnesses, as well as online campaigns aimed at individuals presumed to be connected to the trial. And exactly what were those campaigns? Anyway, moreover, the court is aware the government has arrested and charged multiple individuals in connection with interference with the case arising from conduct including arson, attempted bribery, and harassment aimed at witnesses in this case. See United States versus Russell, United States versus Arline, United States versus Williams. Under the circumstances, we feel that it is appropriate to make these people anonymous. Significantly, despite the case's publicity, two of the alleged victim witnesses, Jane Doe number 2 and Jane number 3, have not spoken publicly about their experiences and instead have maintained anonymity with respect to the allegations against the defendant. While Jane Doe number 5 has spoken publicly about some of her experiences with the defendant, her anticipated testimony at trial will be more fulsome than her prior public disclosures and will include sensitive information that has not been previously publicly revealed. Oh, the stories Miss Girl is about to tell, okay? Publicly revealing the alleged victim witnesses' identities would cause needless anxiety and social stigma, which concerns are further heightened by the defendant's notoriety and the long memory of the internet. Moreover, requiring the alleged victim witnesses to provide publicly full identifying information does not serve any of the legitimate purposes identified by the court, such as the defendants obtaining information for in or out of court investigation or attempting to discredit the witnesses before the jury. Now, I think it is important that people know who they are, because you might know one of these people, right? And you might know that they're lying. You may know that the story that they are telling, and you may want to go to the defense and say, hey, I have information about this case. So what it seems like to me that the prosecutors are trying to do is to prohibit that from happening, okay, to eliminate anyone coming forward at this point and telling the defense what they know about these people, whether they know that they're telling the truth or telling a lie, if they're exaggerating about what happened, if they have information that because Greenberg hasn't been doing his job, Mike Leonard hasn't been doing his job, that they haven't been able to get investigators out in the field to investigate these people, to scour social media, to be able to, get orders for social media outlets to turn over their history and all of this stuff. And so this just is in line with what the prosecution has been doing all along in trying to temper, trying to control the information that is going to get out to the public to prevent R. Kelly from having a full defense in his case, from being able to investigate these people in order to find people who may have contradicting information against these people. So it goes on to say the purposes are directly at odds with the rights that alleged victims are to be afforded under the Crime Victims' Rights Act, which include the right to be heard, but also to be treated with respect for their dignity and privacy. Indeed, inquiring victims of crimes to provide their names in public could chill their willingness to testify for fear of having their personal histories publicized and the embarrassment and humiliation that such publicity could cause them as they rebuild their lives. But it's okay to humiliate, intimidate, and to publicize information about the defendant in the media and have all these crazy stories about him in an alleged, a supposed docu-series or documentary. It was okay to embarrass him and put all that information out without it being proven that it was true, without having the accuracy validated. It was okay to do that, but heaven forbid these women be embarrassed by some of the stuff that they have done and the situations that they willingly put themselves in. So it says, in addition, a ruling requiring the alleged victim witnesses to disclose their full identities publicly could cause other victims, including minor victims, to avoid seeking help from law enforcement because of fear that coming forward could subject them to further harassment and embarrassment, as well as retaliation by defendants' supporters. Okay, whatever. Against this well-grounded need to limit fully identifying them publicly, the defendant will be unable to articulate any particularized need for the disclosure of the alleged victim witnesses' identity information in open court. Counsel for the defendant is currently aware of the identity of the charged Jane Does, which will be confirmed by the government prior to trial, and has been or will be provided with any discoverable statements for the alleged victim witnesses in the government's possession. The reasonable limitations requested by the government, therefore, will not prevent the defendant from presenting a defense. Indeed, the identifying information the government seeks to limit in open court, including the alleged victim witnesses' full names, specific employment, and family information, is largely irrelevant to the testimony of the alleged victims, and I wholeheartedly agree with that. There is a substantial risk, however, that disclosure of such information will identify the alleged victim witnesses with particularity and thus subject them to harassment, retaliation, and embarrassment, or additional consequences such as the need to relocate or loss of employment, blah, blah, blah. United States versus Bennett, court did not err in allowing government witnesses not to identify place of employment where defense failed to demonstrate a particularized need for the information. Conclusion: for the foregoing reasons, the government respectfully requests that the court grant the government's motion in its entirety and limit the disclosure at trial of the alleged victim witnesses' personal identifying information and allow them to testify using only their first names or fake names. Acting U.S. State Attorney Jacqueline Cassulis, and then also by her homegirls Elizabeth Geddes, Nadia Shahata, and Maria Cruz Melendez. So I agree. We don't need to know their personal information. I don't need to know any of their information, to be honest with you. But I can agree that, where they work at, who their family members are, especially for Jane Doe number 2 and Jane Doe number 3, since we haven't, known their information from the beginning. But you can't be requesting that for Jane Doe number 5 because she has put it out there. She has appeared in the documentary. She has appeared in a second documentary. She has done this full-blown article with the Sun Times. So she has already put her information out there. Her dad has been on social media cussing people out for the past 2 years. So why does she need protection from anything? That's what I'm trying to understand. Now, the other two, we don't know who they are. We don't know where they came from, blah, blah, blah. So we don't know. So that I can understand them being a part of this and them making this request to protect their, some of their identity. But child, that Jane Doe number 5 need to go somewhere and sit down. So anyway, guys, that's it for me. As always, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.